You are listening to Parliament Matters, a Hansard Society production supported by the Joseph Rowntree Charitable Trust. Learn more at hansardsociety.org.uk/pm.
Welcome to Parliament Matters, the podcast about the institution at the heart of our democracy, Parliament itself. I'm Ruth Fox.
And I'm Mark Darcy. And coming up this week...
Giving up control? How much say will Parliament have on European regulations under the government's reset with the EU?
Cardinal Wolsey powers. How and why the state has just vetoed the church.
And with the world on fire, is it really a good idea for it to be impossible to recall Parliament for a fortnight before the King's speech?
But first, Ruth, Brexit betrayal or pragmatic economics? We're told that one of the most important bills in the forthcoming King's speech will be the one to implement the government's reset with the EU. Already the bill's being called a mechanism for reversing Brexit, because essentially it's about implementing EU regulations in the UK with minimal involvement by the UK Parliament. So what will it do and how will it work?
We talked to Professor Catherine Barnard, Professor of European Law at the University of Cambridge and a Senior Fellow at UK in a Changing Europe.
At the moment, we are in the course of negotiations over three areas plus youth mobility. And those three areas are SPS, which is sanitary and phytosanitary, which to you and me means animal health, plant health matters. Secondly, energy cooperation. And thirdly, emissions trading schemes. And those three areas will come with quite significant EU legislation. And there will be an obligation under the agreements, assuming we successfully negotiate them, that we will have to dynamically align with the EU, which at the highest level means we've got to keep up with the latest EU rules in those areas.
So essentially, we're agreeing to do whatever they tell us to do in these areas.
It slightly depends on what sort of dynamic alignment we get. Now, I think you'll enjoy this, but in fact, there are different types of dynamic alignment. And effectively, it's a spectrum. At one end of the spectrum, it is pretty brutal. You see that in the Gibraltar Agreement. And there, the UK has to accept all of the EU rules. And if we don't, there is a risk of termination of the agreement. You've also got the Windsor Framework, Northern Ireland Protocol, and there, in respect of the 300 or so areas covered in the Windsor Framework, the UK has got to accept those rules. There is the Stormont break as a sort of get out of jail matter, but in reality, we have to sign up to everything that the EU does in that area. So those are the sort of hardcore dynamic alignment. But if you look at the new Swiss agreements, which have just been negotiated and which the Swiss themselves are going to vote on this summer, there is dynamic alignment, but there's a joint committee between the EU and Switzerland. And if it's considered to be a rule relevant to the Swiss agreements, then the Swiss do have the option to say no. And it's already foreseen that if they do say no in a particular area, sanctions will be imposed, essentially tariffs. And then perhaps surprisingly, the weakest end of the spectrum is the EEA agreement, the European Economic Area Agreement. That's the agreement between the EFTA states, Norway, Iceland and Liechtenstein, and the EU. And there, the EU says a particular measure is EEA relevant. It then goes to a joint committee, and then the joint committee have got to decide whether it will actually become part of the EEA EFTA agreement. And that has been a very slow process. There's things which have been sitting there for years because they haven't agreed it. So the EU has learned from the EEA experience, which is why you see a much tougher approach in the more recent agreements, Windsor Framework, Gibraltar, and the Swiss agreements. It's likely we'll be somewhere closer to the Swiss model, but the bottom line is we will have to sign up to those rules. And if we don't, there will be consequences.
Catherine, we're a rather different size and scale of economy to Norway, Switzerland, Iceland, and so on. For example, our exports, much broader range of exports to the EU. So you say we're likely to be nearer to the Swiss or the hard end of the spectrum. But do you think we will be required to follow one of those sort of models on the spectrum? Or is there any possibility, do you think, of a bespoke agreement to reflect the kind of the size and scale of our economy and also the sort of the developing geopolitical situation in which we in the EU find ourselves?
Well, there is an argument in favour that we might get something bespoke, and certainly the common understanding, which was the text published in May last year, indicated that we might be able to carve some opt-outs. But I imagine the EU will not want to give us too many opt-outs because we are now essentially in the position of, to use the jargon, a demandeur. We're asking to sign up, and we are in a weaker position now than we were when we were a member state. And so it's certainly the case that the common understanding required dynamic alignment without specifying which model, but did say that we would have decision shaping role, which is what the Swiss have and the EEA states have. But again, I think we shouldn't get too excited about decision shaping, because what it means is that the Commission consults states with a decision shaping function. But the moment you get into negotiations, to use the jargon, you get into the tunnel, then the UK will not be at the table.
So if you're designing a parliamentary system to scrutinise these agreements that the UK will be automatically signing up to, it's really just a system for kind of looking at the consequences of them. It's not a system that will have any influence upon them. Is there any way at all that the UK can get any traction over the substance of these rules and regulations that the EU Commission will be putting out in all these different areas?
So the crucial thing is to know what's coming down the track, to get in there at the very early stage when a proposal is merely a twinkle in the Commission's eye rather than some concrete proposal, because by that stage it's already pretty late. And where the Norwegians have really excelled is putting a lot of resource into that very early upstream function. And they spend a lot of time literally having coffee with and wining and dining Commission officials and officials from other member states to find out what is coming down the track. Now, that requires a lot of resource, and lots of people say that UCMIS, the UK Embassy to Brussels, needs more resource so that they are well aware of what's coming down the track. And also, of course, officials in London need to know what's coming down the track. And there also needs to be some way that Parliament, not just Westminster, but also the parliaments in the devolved administrations, need to know what's coming, because particularly in the case of SPS matters, remember that's sanitary, phytosanitary matters, these are areas which have an effect on the competence of the devolved administrations. And so they are entitled to have a say as well.
That's historically something that the UK just hasn't been that good at. I remember this when we were a member state, people would always say we were never ahead of the game.
No, that's right. And it's even more important now that we are ahead of the game, because when we were a member state, at least we were at the negotiating table and we could somehow fists on the table at that stage. But we won't be in that position anymore. So we therefore absolutely need to know what's coming.
In terms of Parliament, I mean, I can imagine the Daily Mail will have a field day with a significant budget for the UK Embassy to wine and dine officials in Brussels.
The foie gras budget's been expanded again. Yeah.
But we are going to have to culturally get our heads around this. But in terms of Parliament as opposed to government, what kind of mechanisms do the parliaments in Norway and Switzerland, for example, have that we could be learning about? Because in Westminster, they've abolished the EU scrutiny committee that did all the sort of technical documentary study of regulations that were coming through. But this is a different scenario. This is much, much further upstream. You know, the UK Parliament has abolished the European Scrutiny Committee that looked at EU regulations coming through when we were a member state. That's gone. We need to be thinking, though, not about what the regulations are when they come through, but, as you say, upstream influencing. So how do other parliaments do that?
I'm not sure any system thinks they've got it right, because this is a rather subtle process, and it's a subtle process largely done through diplomacy rather than through parliamentarians. And of course, as you say, there isn't a concrete text to discuss. Now, I think the abolition of the European Scrutiny Committee in the Commons is a mistake, or certainly will prove to be a mistake, and I think it will have to be reinvigorated at some level, because some of the measures that will be coming through will be cross-cutting. Now, I also accept that some of the SPS measures, the sanitary, phytosanitary measures, may be considered by the committees on food, agriculture, and so forth. But there will need to be coordination that needs to be done. And there also needs to be some sort of oversight from a more generalist body rather than the specialist committees that exist at the moment.
So I suppose it's worth asking here, what's the trade-off that the UK government is engaged in? Because this sounds like the opposite of taking back control. We'd be accepting regulations as they came across in emails, in effect, from the EU Commission. So what advantage does the country gain in the government's mind for doing this?
There's certainly a trade-off, and we will be rule takers. There's absolutely no doubt about that. But the trade-off is that the government takes the view that by being closer, this is good both economically and strategically. Economically, that it will reduce some of the friction on the border, and that will be good for our exports, but also for goods coming into the UK. And the government hopes that ultimately it means that the prices of certain goods in the stores will be less. So there's an economic argument, but I think there's also a strategic argument. The world has changed a lot since Brexit has occurred. It's no longer the time or the place for having buccaneering free trade deals across the globe. In fact, we've got three big powers that are potentially very threatening to us. And it looks like we have far more in common with Europe than we do with the other big powers, and we should get closer to them. That's the government's argument. And in respect of take back control, something we've always known is that it is an exercise of control to decide to surrender some control to achieve other objectives, like the economic and strategic objectives I've just outlined.
There's no doubt it's a democratic deficit. What's the response in places like Norway and Switzerland in terms of their parliaments and their publics to this? Do they sort of live with it as the price worth paying, as you say, for lower prices, less bureaucracy and so on?
Or do they rage against the machine?
Yeah.
Certainly in Norway, there is largely a pragmatism that on balance, it's better to be where they are than totally outside the orbit of the EU. Remember too that Norway is actually a very small country, population of 5 million. And the other thing that's worth thinking about, that why Norway is so different to the UK, is that it really only exports a few products. Gas, oil, very important, particularly at the moment, fish, and also a certain number of alloys. So it doesn't feel quite so exposed in the same way that the UK did when it was a member state, taking rules, but also participating in making the rules in respect of things as broad as financial services, other types of services, as well as goods.
We're already dynamically aligning in some areas voluntarily. You and I, Catherine, over the last year on the product regulation and metrology bill, Mark, that's another niche piece of legislation, which went under the radar of a lot of people in Westminster. And that was a bill essentially to enable the UK to align voluntarily with EU rules on product regulation and marketing and so on. Again, to cut bureaucracy and so on. But we weren't committing absolutely to align in these areas via an agreement with the EU. We sort of did it voluntarily through this legislation. So what's the benefits of reaching an agreement with the EU and signing up to do this in perpetuity, as opposed to voluntarily doing it through something like a product regulation metrology bill model and having the option not to pursue those regulations if we don't want to?
The voluntary model, which underpins the Product Regulation Metrology Act, helps our manufacturers, but it doesn't help with the paperwork because there'll still need to be paperwork to check we comply. Whereas once we've entered into an agreement, dynamic alignment, the paperwork will be significantly reduced because we have formally, bilaterally committed to aligning with EU rules.
So the idea being that the veterinary regulations and the plant health regulations either side of the border will be the same, and therefore the EU is content to get rid of the paperwork, whereas on product regulation they're not.
Exactly.
Yeah.
We're talking here about a bill that we haven't yet seen that will be in the King's Speech, so mid-May the text will emerge and we will be able to study exactly what the government is proposing. But you can already start to imagine scenarios where you get some statutory instrument to implement some EU requirements so that we can have our dynamic alignment. And then there's a great rebellion against it. Why are we complying? Why are we truckling to this evil Brussels over regulation? and then you get a great parliamentary controversy. What would actually happen in that event if Parliament refused to go along with some statutory instrument to implement some piece of dynamic alignment? What does the EU then do?
It rather depends what's in the agreement, but in the case of Switzerland or the revised Swiss agreements, they expressly foresee that as a potential scenario and they prescribe what the sanctions will be, usually tariffs.
So you lose the free trade advantages you're seeking to gain, essentially, if you were talking about, say, an agricultural product.
Exactly.
And is that specific to one particular area? Is it kind of ring fenced to, us not complying with some regulation on cheese, so the cheese gets hit with a tariff, or is it everything?
It very much depends what the agreement prescribes. It could be just on cheese, but it could more likely it will be right across the SPS agreement, but not across the energy agreement. But if there's a breach in respect to the energy agreement, the sanctions will be posed in respect to the energy agreement.
So you can see why this would be quite a flashpoint potentially in Parliament, and you could imagine the Conservatives and Reform constantly trying to force votes on some of these issues, even if they were quite low-grade statutory instruments that would normally be approved on the nod.
Yes, and indeed that happens in Norway as well. And one of the ironies is that the Norwegian government is broadly pro-EU and indeed would like full EU membership. But it's the Norwegian government, when there is a sticky matter, that goes before the Norwegian parliament that's essentially having to defend the rule-taking nature of the rule and thus the democratic deficit.
So the government ends up being quite unpopular on the issue, whereas the opposition parties can have free reign at a pot shop.
They may not be able to win the votes. They may not have the troops in the chamber to do that.
Doesn't matter.
But they have the issue, and sometimes you want the grievance rather than the victory, don't you, I suppose?
Exactly. And of course, at the moment, the government have got a large majority. But if it becomes a coalition government, it becomes much harder.
Yeah. So I suppose what we're looking at here is the content of this bill, the system it proposes, the depth of the agreements that are proposed, and also the systems that perhaps are set up alongside that within Parliament to monitor what's going on. And I suppose the key point I take away from this discussion so far is, as you say, we've got to get ahead of the game. We've got to be knowing what's a gleam in the eye of the European Commission when it wants to regulate something, and get in there and hope that they listen to us. Now, how much does that happen with Norway, with Iceland, with Switzerland? The new cuckoo clock directive that you're proposing would be deadly to the cuckoo clock industry. Can we get in ahead of that and just take this clause out that would be really unhelpful and doesn't really achieve much? Does the European Commission listen to that kind of argument? Or is it thinking, we're the European Commission, we'll do what we want?
Actually, the answer is mixed. And it slightly depends who you talk to. The general view is that the Commission doesn't listen that carefully to what those countries say. However, if it's a highly technical matter and Norway sends some of their really top people who are absolutely on top of the finer details, the Commission, they say, will listen because they do appreciate expertise. There is one concrete example in respect of Switzerland where a change was made. It was in a directive on weapons, which essentially said you can't carry weapons about with you, obviously subject to the very obvious exceptions for military and the police. But in Switzerland, they have military service, and the young recruits are required to take their guns home with them. And it looked like that was going to be ruled out by the directive. And there is a clause in the directive, a provision in the directive, which doesn't in any way reference Switzerland, but was introduced to cover that situation.
Interesting.
Yeah, so that is where presumably the UK government's going to have to put a lot more effort in, and because we're a bigger economy, that's going to have to be a much broader, more extensive effort than some of these other countries are having to make.
Except that, remember, the agreements are only in quite limited areas at the moment, whereas for those countries, particularly for the EEA states, they're bound by the whole range of the single market. We would just be bound by a very small area.
Which raises the point, I suppose, that when we look at the text of this bill, one of the questions is, how much power does it give to make future agreements in other areas beyond the ones we're talking about now? And we don't know the answer, presumably, to that at the moment.
We don't. We know from the Prime Minister that he's looking at other areas where we can explore closer cooperation. People talk about pharmaceuticals and the car industry, perhaps. But it is worth remembering that the three agreements that the UK is currently negotiating with the EU will also help to reduce the friction on the GB-NI border. So that's the border between Great Britain and Northern Ireland, which has already been eased somewhat because of the Windsor framework, which Rishi Sunak negotiated, but nevertheless the friction still exists. Other areas that Keir Starmer has talked about have less impact on the GB-NI border, and therefore the EU's got less interest in negotiating them. It's a multi-dimension game of chess here.
I suppose the key issue in this bill is the implementation part of it, the government's ability to make secondary legislation so that it can implement directives that emanate from the EU Commission in the areas where we've accepted that we're going to take their rules. And those are often going to be in the form of so-called Henry VIII powers, powers for ministers to amend the law, amend primary legislation by making secondary legislation. Now, that's needed, I suppose, because you don't necessarily want an all-singing, all-dancing parliamentary bill with second, third readings, etc. every time you need to do this, because you'll presumably need to do it quite a lot. But it's still an area of enormous controversy.
It is and it isn't. I think we've got to keep this in perspective. When we joined the EU back in 1972-73, the European Communities Act contained a huge Henry VIII power, Section 2.2, which allowed the UK to implement directives via statutory instruments. And while some, perhaps at the more nerdy end of the spectrum, were worried about this, we'd never discussed Henry VIII's powers for decades, really. When we left the EU, there were some major acts of Parliament, most notably the European Union Withdrawal Act, which contained massive Henry VIII powers in order to deliver Brexit quickly. And there were people who were raising deep concerns about the lack of democracy over the use of these Henry VIII powers. But it was a Conservative government that willingly used Henry VIII powers to deliver on its objectives. And now it's a Labour government that's using Henry VIII powers, as far as we can understand it, to deliver on its objectives, which is to have a reset. Now, the House of Lords Constitution Committee has expressed grave concerns about the widespread use of Henry VIII's powers, but the fact is we've been doing it since 72 in European matters, and therefore it comes as no great surprise.
Practically every bill that Parliament passes these days contains powers for ministers to make regulations on this, that or the other. So this isn't some Euro-specific problem. This is something that's quite general across the whole breadth of British lawmaking.
Absolutely. And I mean, it's also worth noting that although we're talking about Henry VIII powers, the Henry VIII powers are contained in a Bill Act, which has gone through the democratic process. And because of the doctrine of sovereignty of Parliament, we can repeal, or a later Parliament can repeal that Act if they don't like it. And we've seen that on steroids when the UK voted to leave the EU and we repealed the European Communities Act 1972.
It's also worth saying, Mark, and I've been banging on to journalists about this week on social media, is that ironically, if it is a Henry VIII power, the Secondary Legislation Scrutiny Committee and the Delegated Powers Committee in the House of Lords will pretty much insist on the scrutiny of the regulations that are made under that power being subject to what's called the affirmative scrutiny procedure. And as listeners will well know, this is my favourite subject. And as a consequence of that, there will have to be a debate and an approval vote in one or both houses of Parliament. For a lot of the other regulations that might come through that are subject to the lower negative procedure, there will not need to be a debate and a vote. So the Henry VIII is a double-edged sword. It's constitutionally difficult and important because it allows ministers by regulation to amend an Act of Parliament, albeit within the confines of a bill that Parliament has approved and has delegated that power to ministers. But on the other hand, there is still a debate and an approval vote on whether or not they're using the powers in an appropriate way. But the reality is, unless and until the House of Commons puts in place proper scrutiny procedures to scrutinise all of these regulations, regardless of which bill they come from, regardless of the nature of the power, then a lot of this sort of debate is just performative theatre by both politicians and journalists.
Yeah.
Put the scrutiny procedures in place and give yourself some grip and some control over it, or simply keep on talking about it.
Yeah. The other point is that the House of Commons, as Ruth kind of hinted there, hasn't exactly covered itself in glory over the years in the scrutiny of all these changes that are made through delegated legislation. And I think ministers are probably perfectly happy that they haven't.
I think it's really interesting that it's Conservative MPs who are throwing up their hands in horror at the use of these Henry VIII powers. When they were in government, that's exactly what they used.
All governments do it, all oppositions oppose it.
That sums it up very nicely.
And dare I ask, Catherine, just one final question. What will be the role of the European Court in this? Because this will undoubtedly be raised by the Conservatives and Reform politicians as a concern. So what would be the role of the European Court?
If there is a dispute about how the UK has implemented one of the directives under the SPS agreement, for example, and the Commission decides to start proceedings against us, the way it's likely to work, 'cause of course we don't know yet because we haven't seen the text of the agreement, is that there is a process. Stage one is usually a political stage. Stage two is arbitration, and that goes to an independent panel. But if the independent panel would like a ruling on the meaning of an EU law provision, then there can be a reference to the Court of Justice to ask what that EU provision means. The ECJ does not have the final say. It actually will be the arbitration panel that has the final say. So there is a role for the Court of Justice, and there is already a role for the Court of Justice under the Windsor Framework Agreement. There's a role for the Court of Justice under the Withdrawal Agreement, which is the divorce text. But that role for the Court of Justice under the Withdrawal Agreement, also under the Swiss agreements, is to interpret the EU provision, not to have the final say on whether we've been in breach.
And just finally, we haven't got the agreement, as you say, but there are suggestions that the bill to enable that agreement in the future might come fairly soon after the King's speech. I mean, I'd heard suggestions that it might come in this session towards the end, even before the King's speech. It hasn't yet emerged. But there is a relationship there between the agreement and the bill. What kind of problems could you foresee if the bill has to be scrutinised by parliamentarians before the agreement is published?
Well, we've been here before. Do you remember the EU Future Relations Bill, which became an act? And you might recall that it's a very odd looking piece of legislation because the first part of the act is very detailed when they'd clearly seen the text of parts of the Trade and Cooperation Agreement, but they hadn't seen the drafters hadn't seen the other parts of the text. So they gave themselves some very wide powers at the end, basically said anything else in the Trade and Cooperation Agreement will become part of UK law too. And the parliamentarians waved that through in what, a day and a bit?
Yeah.
So
for
all the talk about Parliament and parliamentary scrutiny, when it suits them, as it did with the Future Relations Bill, then Act, they will knock it through in a day. And I think I was very struck. I remember that Christmas very vividly because I and a handful of other nerds spent our entire Christmas working our way through TCA, but a number of quite well-known MPs said very proudly that they hadn't even looked at the TCA, that they were prepared to just wave through the Future Relations Bill to get Brexit done. So I do have a degree of cynicism about how much scrutiny actually does get done in Parliament and how much is just dog whistle and they just do what they're told.
I remember that, Mark, that Christmas New Year. We were told that as a result, this bill had to go through incredibly quickly because they had needed statutory instruments for basically New Year's Day to implement the divorce.
I was there in those sittings, watching it from the press gallery.
And we had a rota here at the Hansard Society to monitor the emergence of these statutory instruments on that first day, and they didn't publish any of them. So, yes, I think we share your cynicism to a degree, Catherine.
Happy memories of sitting up in the gallery surreptitiously munching mince pies. Those were the days. Well, Catherine, thanks very much indeed for that. We can see that this is going to keep us chattering here on Parliament Matters for many happy weeks of nerdy detail about secondary legislation in the next session of Parliament. So I'm sure we'll be talking to you again.
And it's good that Ruth is absolutely on top of all the statutory instrument stuff. I mean, she has done a public service for us all.
Thank you, Catherine. That's very, very generous. Well, after that particularly high-fibre discussion, Mark, let's take a quick break. But stick around, listeners, because when we're back, it's Nerdathon time again. Why has Parliament's Ecclesiastical Committee said no to the Church of England's 5-year effort to reform its internal governance? And listeners, while you wait a minute or so, there's something you can do to help us grow the podcast and tackle the tyranny of the tech bro algorithms. Can you rate and review the podcast if you're using Apple or Spotify? Share it with your family and friends, and if you're enjoying it, why not post about the pod on social media so we can reach new listeners? See you in a minute.
In a minute. We're back, and Ruth, something rather unusual happened in Westminster a few weeks back, and it's taken us a while to really digest it. There's a body called Parliament's Ecclesiastical Committee. It dates back about 100 years to an Act of Parliament in 1919, and it's the body that processes changes to the law pertaining to the Church. And these changes are usually things that emanate from the Church of England Synod and the sort of central organs of the established Church in this country. And they had a proposal to reshape their internal governance and create something called the Church of England National Services, which was going to be a charity that disbursed money, provided advice centrally, and did all sorts of other central tasks in the running of the church. And it had sailed through the Synod, this proposal, but it was vetoed, or rather, to be exactly technically correct, deemed to be non-expedient by Parliament's Ecclesiastical Committee, which is a body of 15 MPs and 15 peers, currently under the chairmanship of Baroness Butler-Sloss, a very senior ex-judge. So what's going on? Why has this happened? What's the politics behind it? Because it's very, very rare indeed for this body to do anything other than rubber stamp the proposals before it.
It is interesting, Mark, because as you say, this seemed to sail through the Church of England bodies, and they've been looking at this, reviewing it for about 5 years. An awful lot of work has come to a juddering halt with this committee's decision. Obviously, ecclesiastical matters, ecclesiastical measures, which is what this is, a form of delegated legislation. We talk about statutory instruments, listeners, a lot on the podcast, but when the Church of England is making law, it's their ecclesiastical measures. And it spent 5 years. I was very struck that the committee, when they considered this and they had the bishops in and they had some of the people who've been involved in the review, we had two very senior former MPs, Sir David Lidington, the former Deputy Prime Minister, and Sir Robert Buckland, the former Attorney General, who've been part of this review for the Church of England. And yet the committee said, not happy with this.
And why was that? Well, one of the reasons was your particular pet bugbear, delegated legislation. I suppose in this context, it's not so much Henry VIII powers as, I don't know, Cardinal Wolsey powers or Archbishop Cranmer powers. It was a set of powers that would have been given to this Church of England National Services body that would have allowed it, for example, to rewrite its own constitution by secondary legislation. And a key figure in all this seems to be the formerly Conservative, now Reform MP Danny Kruger, who argued quite effectively in front of the Ecclesiastical Committee that this new body had been given a rather vague remit, the ability to set its own priorities and then to mark its own homework and operate almost independently of anybody else. Other people could comment on what it was doing, but no one else had a veto. So vast amounts of money would be under the control of this body, and it would be able to disperse them according to its own priorities, and nobody else had really much of a say in what it did. And he felt that that was too much independence for that body. And he seemed to convince the committee. I mean, he had quite an interesting set of exchanges there with, for example, Robert Buckland, the former Lord Chancellor, who was saying, oh, for heaven's sake, I paraphrase, he didn't actually use those phrases, and even in the context of the Ecclesiastical Committee, but he was saying that it was a complete exaggeration to say that this body could go off on its merry way and spend its money in any way it wanted. And that was a complete misinterpretation of what the proposals did. But the committee didn't seem to accept that because they deemed the changes that were proposed to be inexpedient. And that means that they don't go forward, they don't get put before Parliament, and the Church of England authorities will now eventually have to decide what they're going to do about it. At the moment, it seems, they're not going to do anything at all. Those proposals are gone. That's it for the time being. And so a series of hot potatoes now lie in the lap of the new Archbishop Sarah Mullally.
Yeah, I mean, it's interesting because this new body that was proposed to be set up, the Church of England National Services, essentially is a charity. And a charity would always have, within its articles, if you like, the ability to amend its constitution, subject to whatever constitutional procedure was established by the charity at the time it was set up. And essentially contained in this measure is a delegated power to enable the Church of England Central Services body, as it was proposed, to do just that. But as you say, people like Danny Kruger were concerned that that was, too broad. I mean, one, for example, the proposal was that the charity would have powers to, adapt for ancillary charitable purposes, which could, mean an awful lot of other things. Could mean a whole host of things that the church could be doing, which might be outside its core remit at the time it was established. And certainly there is a concern that the Church Commissioners, which is the body that essentially controls the church finances, deals with the payment of the clergy, sort of manages the historic endowments. The church commissioners the finance would still stay with them, but the church commissioners would be required to pay the charity, this Church of England National Services body, for what was described as the proper exercise of its functions. And whilst there was some discretion about the overall amount of payment, there wasn't necessarily the discretion about how that charitable body could choose to use the money. So there's this question of accountability at the heart of it. And in total, I mean, there's 9 delegated powers in this church measure, this ecclesiastical measure, which certainly, I think Lord Lisvane, the former clerk of the House of Commons and a former member of the Delegated Powers Committee in the House of Lords, was particularly concerned about.
He had a rather striking phrase. He said that if these powers had been put in front of the Delegated Powers Committee, they would have gone into carnivore mode. So it would have sunk its teeth in quite considerably at the wide range of these powers. And so everybody's backed off now.
Yeah, and that's the extraordinary thing. I mean, as I said at the beginning, this has been a review of the governance of the Church of England over 5 years. And essentially it's come to a juddering halt because, as I understand it, now that the committee has essentially said, no, we're not happy with this, the Legislative Committee of the Church of England or the General Synod could go back to the drawing board, amend the ecclesiastical measure and try again. But apparently the authorities have said, well, the earliest we could reintroduce it would be February next year, apparently. And, that's a long time for all of this to be sitting, in limbo, as it were. And their proposal is essentially they're not going to reintroduce it.
And why do these things matter? Well, amongst other things, there's the issue of safeguarding. Obviously, the various clerical sexual abuse scandals that have been floating around for the last couple of years still weigh very heavily on the Church of England. And one of the things Church of England National Services would have done is provided centralised advice on issues like that. The issue of safeguarding is being looked at by a Church of England internal inquiry at the moment, but the Church is under considerable pressure from the Charities Commission to move further and faster than it seems inclined to do. So again, another hot potato in the lap of the incoming Archbishop. And there's also a matter of clerical conduct hearings. Should they by default be held in private? They've now been pressed so that they should be by default held in public, with the provision to be able to go into private session if it was necessary for some reason to do so. So there's a bit of openness being injected in the system there. But there are a lot of issues around church governance in play at the moment. And the feeling is that it seems on the committee that these proposals actually complicated things, didn't provide enough accountability, and so they've been pushed to one side. So quite an interesting exercise in a usually quite dormant parliamentary body suddenly flexing its muscles.
Yeah, and essentially what's happened is 15 MPs, as you say, 15 peers, so 30 parliamentarians have essentially stopped the reform of the governance of the Church of England, which the Church itself, through its own procedures and its own bodies, the General Synod not least, had essentially passed through, as I understand it, with quite substantial margins of support. And, 30 parliamentarians, hands up, no, not happy with that.
That's what happens when you've got an established church.
Yeah, it brings to the fore, doesn't it? There's a really interesting debate about the relationship between church and state and the role of church accountability to Parliament. And unless, frankly, you're reading the Church Times, I don't think you've come across this.
It won't have been covered too
attention.
much.
No.
And the existing system dates back to an Act of Parliament in 1919, and there is some thought that maybe a century on it's time to update the parliamentary side of Church of England governance as well, and maybe it's time to have an actual full, all singing, all dancing Church of England Select Committee in Parliament. Just a thought. There are a few people out there who seem to like that as an idea, but I don't think it's got much play at the moment. And you imagine it's probably not top of the government's priorities either, but wait and see.
Yeah. Well, it's really interesting development. So we'll see if anything further emerges, whether that committee's one that we'll keep an eye on.
Yeah, it's just a thought that, 20 odd years of reporting Parliament at the BBC, I barely noticed the Ecclesiastical Committee at any point. The one time I did notice it was I happened to be browsing a list of new Select Committee members, and a Conservative MP called Patrick Mercer, who I knew a bit because he'd once worked at the BBC, was appointed to this committee. I was slightly surprised. He's best known as a former army officer. And I mentioned this, and he said, Am I really on this committee? And it turned out that he was on it on the basis that his father had been a bishop. But he wasn't even aware, well, at least as he said to me, he wasn't even aware he was on it until I told him.
Yeah.
Wow.
Well, I think if you look down the list of MPs and peers, when they do their list of interests at the beginning, that's quite interesting. I'm a trustee of so-and-so in relation to a church, or I'm doing fundraising for this cathedral, or I'm sitting on this particular church body, or in some instances, I'm married to a Church of England vicar. So it was quite interesting.
Yeah. It's one of the roads less travelled in Parliament, shall we say, but watch this space.
But not on Parliament matters.
Here we are again.
Right, Mark, I think we should take another quick break and then come back and talk about, well, I want to have a go at another bit of parliamentary activity that's gone under the radar this Easter, which is the appointment of the Armed Forces Commissioner, and also talk about prorogation and whether or not it's a good idea for Parliament to basically take a break for the next couple of weeks in the run-up to the King's Speech when, well, frankly, the world is on fire.
Oh, I'm sure nothing much will happen. Cross your fingers.
See you in a minute.
Bye. And we're back. And Ruth, you've had rather a busy Easter break. There I was on Easter Monday, scrolling as I do through my social media feeds, and suddenly there you were, in quite a considerable and extended Twitter rant. I mean, you didn't, to your credit, post a picture of yourself as Our Lady or anything like that, but you were quite
on Truth Social.
You were quite exercised about the appointment of an Armed Forces Commissioner. We've talked about this on the pod before, but there's going to be this new kind of ombudsman figure for service personnel, and the appointment is now made, and it seems to have been a curiously perfunctory and rather rapid, possibly dangerously rapid process.
Yeah, what really astonished me was that it was the timeline for the appointment. I mean, the Armed Forces Commissioner bill was passed, last September, got royal assent. And this, listeners, was promised in the Labour manifesto. The government made a great deal of this at the time that royal assent was granted. There was this going to be an independent person modelled on the German Armed Forces Commissioner model, an independent commissioner accountable to Parliament, tasked with championing service personnel and their families and their needs and concerns and so on. And I've been looking out for the appointment because it was all due to come into force in April, so this month. And the person who was going to be appointed was going to be subject to a pre-appointment hearing by a select committee. As you know, we do our weekly bulletin where we trawl through what's happening in the week ahead in the order paper. So I've had my eye out on select committees. When is the Defence Committee going to get the appointment to get the person in front of them to discuss their suitability for the post and why they're the government's preferred candidate? And as of Easter, nothing had happened. There'd been no announcement, which I thought was curious. And I've seen that there's been some parliamentary questions tabled by the opposition party about it and frankly got non-answers to it. And then all of a sudden I realised the government on Easter Sunday put out a press release saying that the Armed Forces Commissioner had been appointed. But you had to read down to the next to last paragraph of this 13-paragraph press release to discover that it was a temporary appointment for 12 months only, which sort of, tipped me off that possibly this hadn't been quite the great success that the government had perhaps hoped for. And it turned out that the Defence Committee, in the last days of Parliament before Easter, had indeed had a pre-appointment hearing, but it had been arranged so quickly, it hadn't been listed at the time we'd done our bulletin on the Sunday, when just a couple of days later they had to have the hearing, so we missed it. And I did a bit of digging, and it turns out that the person who's been appointed, who I should say, my critique here is nothing against her. She's a former RAF officer called Polly Miller-Perkins, CBE, has a very distinguished service record. But it turns out that she submitted her CV to the Ministry of Defence on the 3rd of March this year. She was interviewed online by the Defence Secretary, John Healey, 10 days later on the 13th of March. The following day, she was offered the job. And then on the 25th of March, so 9 days later, she appeared before the Commons Defence Select Committee for a pre-appointment hearing. And on the 1st of April, she assumed the legal duties of the Commissioner. Now, bearing in mind that the government had started the appointment process, the recruitment process for this post, in summer of last year, and earlier this year had said that they'd got 5 candidates being interviewed, clearly that recruitment process did not throw up anybody who was suitable. So the question was, why was this person in what was described as not a competitive recruitment process. Why was this person approaching the MOD with her CV at the beginning of March and then by the end of the month had been appointed and was in post? And it turns out, and you have to read through the Defence Committee's Select Committee report and the various sort of papers that have been submitted around that, it turns out that she'd heard about the post through the Labour MP Calvin Bailey, who she'd worked with in the RAF 10 years ago. She'd not had any contact with him in the interim, apparently, but he'd asked her why she hadn't applied for it. And he said to her, I think they're having some difficulties finding somebody for the post, so why don't you submit your CV? So she did. And within less than a month, she'd been interviewed, had her pre-appointment hearing and was in the job. So it's pretty extraordinary. And
it's not how you normally do a big government appointment like this. I mean, it may not be quite as big as a major industry regulator or a Bank of England committee member, but it's still pretty significant to the lives of potentially thousands and thousands of service personnel.
Yeah, and I think if you're going to do a pre-appointment hearing for somebody, the Defence Committee basically got a few days' notice and had to hold the hearing very, very quickly. So quickly that some of the members of the committee couldn't attend because they hadn't planned to be having that meeting. They'd had an earlier meeting that week that had been in the diary. This one wasn't. So it wasn't a full committee hearing. They had not had the time to think about and reflect upon her CV and her answers to the questions. The hearing was shorter than it would normally be as a result. And she performed perfectly well in front of the committee, and indeed the committee have endorsed her appointment and said they're satisfied with it, that she's got the experience, the skill set, the commitment and so on to do the role. But obviously it's only for a temporary 12-month period. And it's not clear what the government is now going to do in terms of recruiting somebody on a full-time basis and whether there's going to be a new competition opened up for the post.
Are both sides testing the water, and it may be that she simply stays in post and is confirmed there for a longer term, or alternatively, are they going to say, one or the other of them going to say, this isn't working out, let's find someone else?
But for me, and there's a sort of a broader question then about accountability to Parliament. This bill that got royal assent last September made a big deal about all of this. They'd launched what turned out to be a 9-month recruitment process, which clearly failed in the sense of bringing forward a candidate that they thought was appointable. The successive ministers have failed to really answer written parliamentary questions from opposition MPs about it. They've stalled, they've stonewalled, they've not answered the question properly with any detail. You know, there were questions from the Shadow Defence Secretary, James Cartledge, there were questions from the former military officer, Conservative MP, Ben Abasi-Jekti, and they didn't get answers. And even now it's still not clear what the government's plan is going to be in terms of the future. There's no accountability about what happened to this recruitment process. So you might not want to go into details about individual candidates and why they weren't appropriate, but you might be able to flesh out some detail and the background of why you think the recruitment process didn't work and what are you going to do next time to put it right.
But the first person who takes this job often sets the parameters for their successors. So
Exactly.
It's very, very important to get it right and have someone who feels they've got authority. And I wonder if you've got someone in I don't know what you call it, temporary tenure, whether they will really feel they've got the freedom to set the rules and set the precedents that someone in this job really needs to set. So it's not ideal from any number of points of view.
No, absolutely. I mean, at the time she had the pre-appointment hearing in front of the Defence Committee, she acknowledged she hadn't even yet got her contract. So she was asked a question by one of the members of the Select Committee about, are you a permanent appointment? Are you employed on a civil service contract by the Ministry of Defence? Or because it's temporary, are you on a consultancy contract? Interestingly, her actual response was that she thought she was employed by Parliament, which isn't true at all. She's accountable to Parliament, but she's not employed by Parliament. So
inspectors are normally a sort of a Crown appointment, aren't they, rather than a straight civil service appointment. So they shouldn't be under the direct line of accountability to a minister.
Yeah, she described herself as a direct appointment of Parliament. Well, that's just not accurate. The other thing that was interesting is she was asked about the location of her office, and obviously things were getting up and running, and she obviously didn't perhaps know where her office was, but she wanted access to the MOD. She thought she should have free access to the MOD, but she wanted her office, she thought her office would be nearer Parliament. So that in itself is quite interesting, is where does she think she's going to be based, and does she imagine that she ought to be based in Parliament? That would raise a whole set of questions. I think she'd probably be disabused of that in the coming weeks. But yeah, the plan initially if you go through the various correspondence between ministers and the Defence Committee about this back through last year, the plan was initially to have a pre-appointment hearing last November. So that didn't happen. So between November and essentially mid-April, there has then been this vacuum of information, at least in public, about what's been going on. And as you say, the idea was that you'd have somebody in post early in the new year so that they could help to shape the development of the office and how it's going to function and the setting up of systems. And yet there she was, essentially getting appointed and into office within a matter of days when all of these powers are suddenly hers. So it seemed to me a very unsatisfactory process on a number of fronts, but particularly the lack of ministerial candour with the Defence Committee members and with other shadow opposition members about what was happening with the appointment. And you can see that in the answers, the stonewalling answers to the Parliament, perfectly legitimate parliamentary questions to ask when Parliament has passed an act at the government's behest to set this post up, and there's a public appointment process going on, and resources are going to be spent on this and directed to the Office of the Armed Forces Commissioner. Just a complete lack of accountability. And because we're coming up to the end of the session, there isn't now going to be defence questions until the other side of the King's Speech. So you'll be into May before there'll be an opportunity to learn more.
And there may be a few other issues taking up the minds of defence specialists in the Commons by that point.
You'd think.
You'd
Yeah,
think.
and that's the problem, I think. That's the challenge, is that there's so much going on in terms of the defence debate that understandably other issues are being prioritised, but accountability does matter.
Well, Ruth, let's turn to another minor parliamentary mystery, which is what's happened to the Northern Ireland Troubles Bill. Now, the government has been replacing the previous government's legislation on dealing with the legacy issues from the Northern Ireland Troubles with its own bill, and that bill has mysteriously gone into limbo, and we now have a new theory as to why that might be.
Yes, so we have some of the best listeners who get in touch and help us with information and intelligence that they pick up. So, listeners, if you remember on our last episode before Easter, we did some questions from listeners about a variety of things, but one in particular was, as you say, what had happened with the Northern Ireland Troubles Bill. It had its second reading, I think, in November, and it's been stalled ever since. And we were not sure, but we thought it was possibly that they just couldn't agree on how they were going to handle this delicate legislation about the Troubles. But it turns out there may be something else in the background here. So one of our listeners, Rory Hipkin, thank you, Rory, for getting in touch. He suggested that the current legislation that was passed by the last government in relation to the Northern Ireland Troubles, that this new government bill is going to repeal, has been challenged by way of judicial review in the Northern Ireland High Court, and for a variety of reasons after it was enacted, things about compatibility with the EU withdrawal agreement, for example. That case has apparently made its way to the UK Supreme Court, and there was an appeal in October of last year, but the judgment has not been published yet. So that is still awaited. So we can't be certain, but it doesn't seem unreasonable to think that actually the government may be awaiting the results of that Supreme Court judgment before moving to the next steps. And it may be as a result of that judgment they have to make some changes to the legislation.
Well, you could imagine they might have to build in some of the Supreme Court's conclusions into the new legislation, and it would avoid a lot of trouble if they just waited until that happened.
Yeah.
So, yeah, I can see that as quite a compelling reason for holding fire for the time being.
Yeah, so the bill will carry over into the next session, so there's no problems with the government on it. But interesting, and thank you, Rory, for that bit of intelligence. That was really helpful. And Mark, we got a mention in the House of Lords. We shouldn't let that go by. A podcast was mentioned by Baroness Sarah Ludford, the Lib Dem peer, in the debate on the statement of changes to the immigration rules earlier this week.
She found our pod thoughts on that quite helpful, apparently. So thank you, Lady Ludford. We keep a nice exhaustive list of all parliamentary references to this podcast for our own advertising purposes, so that's another one in the box. And as this parliamentary session draws peacefully to its close, Ruth, there is a bit of an issue, and it's around the word peacefully. On current plans, Parliament is due to prorogue or suspend itself in the week beginning the 28th of April. And after that, if it's prorogued, nothing can happen in Parliament under most circumstances until the next King's Speech, which will be on May the 13th. And that will be slightly more than 2 weeks away. And with the world on fire, with all sorts of crises in the Persian Gulf and all sorts of other issues going on. Is that entirely wise? Should Parliament deny itself the ability to meet if there is some moment of crisis that deserves its attention in that 2-week period? Because it's highly possible that there might be.
Well, no, I don't think it is wise. And what happens is that for prorogation, Buckingham Palace, on the advice of the Privy Council, makes an announcement of a date range for prorogation.
Yeah, this gives it a bit of flex so that they wait till they've got all the bills done, and that'll be between date 1 and date 2.
Yeah.
And once all the work is done, bang, you can have your commission going in and proroguing Parliament.
Yeah, and this is the bookend to the state opening. So, it kind of mirrors, prorogation will mirror the state opening. Black Rod has to go to the House of Commons, summon the Commons, the MPs into the Lords' Chamber. There's a Royal Commissioners, 4 or 5 senior members of the House of Lords
Much
doffing
of
their
tricorn
caps.
hats. And...
Yeah, but the date range that has been chosen for this prorogation is 29th of April to the 6th of May. Now, bear in mind the King's Speech is the 13th the following week, so it's up to the date before, the Wednesday before the local elections. Now, if they go to the 6th of May, then you've got a week without Parliament, which some would say is still not ideal, but...
It's not utterly unmanageable.
It's not utterly unmanageable. If you go 29th of April, you're talking about an extra week or so beyond that. Now, I'm hearing suggestions that indeed the government would like, and indeed some of the other parties would like, to be done by the 29th of April.
And actually the forward parliamentary business that was published a few hours before we started this recording doesn't have anything after the 29th of April. Now that doesn't preclude, a bit more consideration of Lord's amendments if there's still ping-pong going on some bill or other. But broadly speaking, it suggests the expectation is the 29th of April is the date.
Yeah. Now, what does that mean? If once they prorogue, parliamentary business falls away. So things like parliamentary questions fall, motions fall. Obviously, bills have either got royal assent or they've been carried over. Select committees, their inquiries can carry on into the next session. They'll resume where they left off, but you don't get publication of reports and so on, and they can't hold hearings. But the critical thing is that they can't recall Parliament during that period of prorogation.
I think the only possible circumstance is the death of the monarch, isn't it?
There's 2. So there's death of the monarch, and there's also if they had to use regulations made under the Civil Contingencies Act, which has never happened.
Emergency situation, essentially.
That is the nation's highest level national emergency legislation. So if a nuclear bomb lands, then, you'd need national emergency legislation perhaps, and that's what would be used. And the powers are so considerable. Essentially, ministers can do whatever they deem necessary to do. They can take over property, they can access funding. There's a whole series of things. They require Parliament to renew them periodically and after a matter of days. So there's provision to recall Parliament for that. But other than that, if there was some major development in the world that involved, an attack on Britain or attack on British interests, attack on British allies, attack on our armed forces, whatever it might be, or indeed if it was an economic problem, something happens as a result of what's happening in the Middle East and there are economic difficulties, or we suddenly haven't got access to some particular product or whatever, and that has an impact on the economy, Parliament can't be recalled in those circumstances. And that seems to me to be concerning. The government doesn't have to prorogue straight away. It could adjourn and then prorogue. Now, that would mean that on whatever day they decide to prorogue, which could, should be the 6th of May, they'd have to get some MPs and peers back for that day to do it. But they don't need many of them.
Yeah, well, I suppose you can come up, to May the 12th if you wanted to, and prorogue on May the 12th and have the state opening the next day.
I don't think they can now. They've issued the
now they've issued it, but in theory they could have done. They could have had a provision. But I suppose if you think back to the halcyon days of a few weeks ago before we had all this madness going on in the world, maybe it seemed a perfectly normal way to go about things.
Yeah.
And suddenly we're in an emergency situation. It doesn't seem to me that it's beyond the realms of possibility to change the arrangements, even at a late date, even if it means reversing what had previously been announced, so that you do have the ability for Parliament to sit if necessary. It's not the absolutely central thing that a government may want, but I think Parliament ought to want it.
Yeah, and I think that's that's kind of the critical thing. But the politics of this, of course, they're looking at it in a different way. From the government's perspective, given the local elections, the concerns they've got about that, they're quite happy to have the MPs away from Westminster. The other political parties want to get out campaigning because they want to be focused on those local elections and trying to deliver a good result. So for different reasons, I think the politics are playing out in a way that, not particularly addressing the concerns that you and I have got. But I think from the government's perspective, in terms of risk management here, I think really it would be better to adjourn until the 6th of May and then prorogue. But I gather that's not the plan.
Yeah, strange but true. But there we are. That's the way it seems to work these days.
Indeed. Well, I think that's probably all we've got time for this week. You never know, there may be MPs listening who will perhaps have a think about whether or not proroguing on the 29th of April is a good idea. We might come back with different news next week.
Who knows?
But we'll see you next week. And listeners, just as ever, before you go, can we ask you to rate, review and share the podcast so that we can help find more listeners?
Always helps to grow the pod. Till next week, goodbye.
Bye, Mark.
Parliament Matters is produced by the Hansard Society and supported by the Joseph Rowntree Charitable Trust. For more information, visit hansardsociety.org.uk/pm or find us on social media at Hansard Society.